ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇರ್ಲಿ, ನಿಮ್ ಡಿಫೆನ್ಸ್ ನೀವು ಚೆಕ್ ಕೊಡ್ಲಿಲ್ವಾ?
We are
Check
issued the
ಕೊಟ್ರಾ?
check, my lordship, not in the company's name, my lordship. Respondent ಏನಿದ್ದಾರೆ ಅವರಿಗೆ ನಾನು ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೆ, ಅವ್ರು ಚೆಕ್ ತಗೊಂಡಿದ್ದೇನೆ ಅಂದ್ರೆ ಇಂಟೀರಿಯರ್ ಐಟಮ್ಸ್ ನ ಪರ್ಚೇಸ್ ಮಾಡೋದಕ್ಕೆ ಅಂತ ಹೇಳಿ ಸೈನ್ ಬ್ಲಾಂಕ್ ಚೆಕ್ ತಗೊಂಡಿದ್ರು.
ಏನ್ ನಿಮ್ಗೆ ಗೊತ್ತಾಯ್ತಲ್ಲ ಮೋಸ ಆಯ್ತು ಅಂತ, ಏನ್ ಮಾಡಿದ್ರಿ?
ಆ ಟೈಮಲ್ಲಿ ಏನು ಮಾಡಿಲ್ಲ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ಆ ಟೈಮಲ್ಲೆಲ್ಲ ಇಲ್ಲಿವರೆಗೂ ಮಾಡಿಲ್ಲ.
ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಏನಂತ ಮಾಡ್ಕೊತಾರಮ್ಮ?
50,000 rupees ಫರ್ಮ್ ಹೆಸರಲ್ಲಿ.
ನಾನ್ ಮೋಸಗಾರ,
ಇಲ್ಲ
ಕಂಡೋರ್ ಚೆಕ್ ನನ್ನ ಬ್ಲಾಂಕ್ ಚೆಕ್ ನ ಮೋಸ ಮಾಡ್ಕೊಂಡು ತುಂಬ್ಕೊಂಡ್ಬಿಟ್ಟಿದೀನಿ ಅಂತ ಹೇಳಿದಾರಾ?
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ಏನಂದ್ರೆ 50,000 rupees ಫರ್ಮ್ ಹೆಸರಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗುತ್ತೆ. ಸೊ ಇನ್ನ ರಿಮೈನಿಂಗ್
ಎಲ್ಲ ಹೆಸರಿನಾರ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಲಿ, ಅಮೌಂಟ್ ಇನ್ ಚೆಕ್ ನ ನಾವು ವಿ ಕ್ಯಾನ್ ನಾಟ್ ಗೋ ಬ್ಯಾಕ್ ಆನ್ ದಟ್ ಬಿಕಾಸ್ ಆಫ್ 139. Look at it, 139 wordings in 139. Look at 139 wordings in section 139 of IPC, ಇದು Negotiable Instrument Act.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ನಾನು ಬುಕ್ ತಗೋ ಬಂದಿಲ್ಲ.
ಇದು ತಗೊಳ್ಳಿ, ಇಲ್ಲೇ ಪುಸ್ತಕ ಇದೆ, ಚೆನ್ನಾಗಿ ಓದ್ಬೋದು ಅದ್ರಗಿಂತ. 139 ಅಂತಿದೆಯಲ್ಲ, ಮೊದಲು 118 ಅಲ್ಲಿ ಒಂದು ಪ್ರಿಸಂಪ್ಷನ್ ಇದೆ. ಈಗ ತೆಕ್ಕೊಟ್ಟಿದ್ದೆ, ನೀವು ಎಲ್ಲೆಲ್ಲೋ ಹೋಗ್ಬಾರ್ದು, ಅದಕ್ಕೆ ಈಸಿಯಾಗಿ ತೆಗೆಸ್ಕೊಟ್ಬಿಟ್ಟಿರ್ತೀರಿ 139 ಅಂತ.
Yes my lordship.
ಓದಿ.
Presumption in favor of the holder if shall be presumed.
ಹೋಲ್ಡರ್ ಅಂದ್ರೆ ಯಾರು? ಇವ್ರೆ ಅಲ್ವಾ? ಸೊ ನೀವು ಯಾರಿಗೋ ಕೊಟ್ಟಿದ್ರು ಕೊನೆಗೆ ಯಾರ ಹತ್ರ ಇರುತ್ತೋ ಅವರು ಹೋಲ್ಡರ್ ಅಂತ.
Yes my lordship.
ಯು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್?
Yes my lordship.
ಈಗೆಲ್ಲ ಹೇಳ್ತಾರಲ್ಲ, ರಾಧಮ್ಮಂಗ್ ಕೊಟ್ಟೆ, ರಾಧಮ್ಮ ತಗೊಂಡೋಗಿ ಇನ್ಯಾರಿಗೋ ಕೊಟ್ರು ಅಂತ, ಅವ್ಯಾವ್ದು ನಡೆಯಲ್ಲ. ಪ್ರಿಸಂಪ್ಷನ್ ಇನ್ ಫೇವರ್ ಆಫ್ ದಿ holder of the check. Yes, read it.
Unless the contrary in provided that the holder.
Provided.
Proved.
ಮತ್ತೆ ಎಲ್ಲರೂ ಪ್ರೊವೈಡೆಡ್ ಅಂತ ಓದ್ತೀರಾ, ಬುಕ್ಕೇ ಮಿಸ್ಟೇಕ್ ಏನು ಅಂತ ನಂಗೆ ಡೌಟು.
Proved that the holder of the check received the check of the nature referred to the section 138 of discharge in whole or in part of any debt or other liability. ಆಯ್ತಲ್ಲ ಅಲ್ಲಿಗೆ. My lordship,
ಹೋಲ್ ಪಾರ್ಟ್ ನೀವು 50,000 ಕಾರು ಕೊಟ್ಟಿರಿ, ಎಟ್ಟಾರು ಕೊಟ್ಟಿರಿ, ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀಮತಿ ರಾಧಿಕಾ.
ಅಲ್ಲ, ನಾನು ಅವ್ರ ಹತ್ರ ಸೆಟಲ್ಮೆಂಟ್ ಚಾನ್ಸಸ್ ಕೇಳ್ದೆ, ದೇ ಆರ್ ನಾಟ್.
ಕೊಡಲ್ಲ. ಅವ್ರು ಯಾಕೆ ಕೊಡ್ತಾರೆ? 2 ಕೋರ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ.
ಥಿಂಗ್ ಏನಂದ್ರೆ ಅವ್ರು ವರ್ಕ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿರೋದಕ್ಕೆ ಯಾವ್ದೇ ರೀತಿ.
ಆಯ್ತಲ್ಲಮ್ಮ, ಅದೆಲ್ಲ ಹೋಗಿ ಬೇಕಾದ್ರೆ ಆಮೇಲೆ ನೋಡಿ, ನೀವು ಕೇಳಿ. ದುಡ್ಡು ಕೊಡ್ತೀರಾ ಇವತ್ತೇನಾರು?
ಅವ್ರು ನಾನು ಅವಾಗ್ಲೇ ಮಾತಾಡ್ದೆ.
ಇವಾಗ ಏನಾರು ಕೊಡ್ತೀರಾ?
ಟುಮಾರೋ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಇವತ್ತೇನಾರು ಕೊಡ್ತೀರಾ?
ಅವ್ರ ಹತ್ರ ಡಿಸ್ಕಸ್ ಮಾಡ್ಬೇಕು, ಪಾರ್ಟಿಗೆ ಹೇಳ್ಬೇಕು.
ಇವತ್ತು ಕೊಡ್ತೀರಾ ಅಂತ ಕೇಳಿದೆ, ಇಲ್ಲಾಂದ್ರೆ ಬರ್ಕೊಳ್ಳಿ, ಜಜ್ಮೆಂಟ್ ಅಷ್ಟೇ. Accused who suffered an order of conviction in CC number 16990 of 2017, confirmed in criminal appeal number 1601 of 2018, has preferred this revision petition. First, next para. Facts in brief for the disposal of the revision petition are as under. Upon the receipt of complaint by the complainant under section 200 CRPC alleging the commission of the offence under section 138 of the Negotiable Instrument Act, contending that complainant is in the business of interior designing and accused approached the complainant for the purpose of interior design of newly constructed house, and in that regard, the complainant presented a bill in a sum of ₹6,43,827, wherein part payment to the extent of 90,000 was made by the accused, and for the balance sum he passed on a check in a sum of ₹5,53,827 towards the full and final settlement of the bill. Said check on presentation came to be dishonored and legal notice issued which was not complied. Accordingly, he sought for action. Learned magistrate took cognizance of the offence punishable under section 138 of the Negotiable Instrument Act and secured the presence of the accused. Full stop. Plea was recorded, accused pleaded not guilty, therefore trial was held. Next, for an order to prove the case of the complainant stepped into the witness box, got examined himself as PW1 and placed on record 12 documents which were exhibited and marked as exhibit P1 to P12, comprising of authorization letter, dishonored check, bank endorsement, copy of the legal notice, tax invoice, income tax returns, VAT form, partnership deed and form number C. First, accused statement as contemplated under section 313 CRPC was recorded, wherein accused has denied all the incriminatory circumstances. First, next para. As against the evidence placed on record by the complainant, accused got himself examined as DW1 but did not place any material on record to probabilize his defense. First, next para. Thereafter, learned trial magistrate heard the parties in detail, and after considering the oral and documentary evidence placed on record raise the presumption in favor of the complainant as is available under section 139 of the Negotiable Instrument Act and convicted the accused for the offence punishable under section 138 of the Negotiable Instrument Act and imposed the fine in a sum of rupees 3,28,000, of which sum of rupees 3,25,000 was ordered to be paid as compensation and balance sum of rupees 3,000 was ordered to be paid as defraying expense of the state. First, next para. Being aggrieved by the same comma, accused preferred an appeal before the district court in criminal appeal number 1601 of 2018. Next para. Learned judge in the first appellate court after securing the records and hearing the parties in the light of the grounds heard in the appeal comma, dismissed the appeal and confirmed the order of conviction and sentence passed by the trial magistrate. First, being further aggrieved, next para. Being further aggrieved by the same comma, accused is before this court in this revision. Next para. Srimati Radhika, learned counsel for the revision petitioner, reiterating the grounds heard in the revision petition, comma, vehemently contended that the work was not completed by the complainant and therefore there was no legally recoverable debt for which the check has been issued and the check which has been given by the accused as security for completing the interior decoration work, comma, has been misused by the complainant and therefore, comma, there was no liability on the accused to pay the amount covered under the check, and as such, the dishonor of the check has taken place, which aspect of the matter has not been properly appreciated by the learned trial magistrate or the learned judge in the first appellate court, resulting in miscarriage of justice and sought for allowing the revision. Okay, next. Per contra, learned counsel for the revision respondent supports the impugned judgments. Next, for having heard the parties in detail, this court perused the material on record meticulously. On such perusal of the material on record, comma, parting away the check in question and signature of the accused therein is not in dispute. First, according to the accused, comma, the check has been misused. First, no positive action has been taken by the accused, at least after appearance before the trial magistrate about the alleged misuse of the check. First, admittedly, there was a transaction between the complainant and accused with regard to the interior decoration work carried out by the complainant firm in the house of the newly built house of the accused. First, next para. If at all the check is misused, comma, no normal prudent person would keep quiet, at least when such person had the legal assistance when they appeared before the trial court. First, in the absence of any such positive action taken by the complainant and having regard to the fact that the transaction is admitted and issuance of check is not in dispute, comma, learned trial magistrate was justified in raising the presumption under section 139 of the Negotiable Instrument Act in favor of the complainant in convicting the accused. First, further, comma, the oral testimony of DW1 was not sufficient enough to rebut the presumption available to the complainant. First, both the courts have taken note of this aspect of the matter in a pragmatic manner and passed the order of conviction and sentence. First, in the revisional jurisdiction, this court does not find any good grounds to interfere with both the judgments. Accordingly, comma, conviction is to be maintained. First, next para. Having said this, comma, since the lessee is privy to the parties, PRIVY, privy to the parties, comma, imposition of rupees 3,000 as the fine amount towards the defraying expense of the state needs interference by this court in this revision. First, accordingly, following order, criminal revision petition allowed in part while maintaining the conviction of the accused for the offence punishable under section 138 of the Negotiable Instrument Act, awarding a fine amount of rupees 3,28,000 is reduced to sum of rupees 3,25,000. First, entire amount of rupees 3,25,000 is to be paid as compensation to the complainant, failing which accused shall undergo simple imprisonment for a period of 1 year. First, next para. Payment of fine amount of rupees 3,000 payable to the state towards the defraying expenses is hereby set aside. Time is granted for the revision petitioner to pay the balance amount till 10th of July 2024.